A married woman didn't have the right to enter into a contract in her home state. She took out a loan in a state in which she had the capacity to contract, but signed the paperwork from home. After she breached the contract, the court tried to marry conflict of law principles and contract law in University of Chicago versus Dater. Two married couples, the Daters and Prices, lived in Michigan. George Dater and John Price owned property in Chicago, Illinois. Together with their wives, Nellie Dater and Clara Price, they used the property to secure a loan for $75,000. Negotiations took place in Illinois, but George, Nellie, John, and Clara signed the loan agreement in Michigan. Then they mailed the agreement to Illinois, where it was recorded. The promissory notes were payable to the city of Chicago, but Chicago could appoint someone else to receive the payments. John died, and Clara became the owner of John's interest in the Chicago property. George, Nellie, and Clara stopped making payments. Chicago had appointed the University of Chicago to receive the loan payments. The university sued George and Clara for the outstanding money on the loan in a Michigan court. The trial court entered judgment for over $15,000 against George, but the court entered judgment in Clara's favor, citing Michigan's coverture law. Coverture was a legal doctrine that meant a married woman had no independent legal rights or obligations from her husband. Under Michigan law, Clara didn't have the capacity to contract for the loan in the first place, so she couldn't be liable for the unpaid amount. The university appealed the trial court's judgment in favor of Clara.